So let's carry on. We've looked at a list of things we needed to do. So your client is sitting in front of you and you need to do a little bit of preparation before you put your hand to paper. And so the first thing you need to know is whether your client has testamentary capacity. And what is testamentary capacity? It's 16, but what else?
If they're not mental capability, like not focus.
Of sound mind to understand the nature and effect of what he is doing. That is very important. And how does testamentary capacity differ from legal capacity?
Isn't it only that you can only make a will, but you're not allowed to do other legal contracts?
Yes, and what is the age for legal capacity? 18. Okay, so there is quite a difference. I often get asked, but why? It is simply an historical fact. Because in Roman times, a person often took over the whole family as the pater familias when he was 16, and that's where it still comes from. As time went on, people realized, but if you that young, you cannot go into contracts. Of course, earlier it was 21, now it's gone back to 18. So that is why there's a difference in age. There's no real other reason for it except that it's historical. So at the age of 16, you can make a valid will. Then your document. What qualifies as a testamentary writing? As we said earlier, it's important to know that because you have to know whether that piece of paper has to comply with the formalities. And I see nobody was inventive enough because your testator says he had a map that he wanted to attach as well as photos that he wanted to attach. Why did I add that into your facts? Because a testamentary writing is a document that contains any one of the following. Please note, it's not all three, it is any one. Either the beneficiary, the benefit, or the extent of the benefit that is being bequeathed. In other words, where your testator said, I've got photos that I want to attach, is that a testamentary writing? What does that identify?
Identifies the asset that needs to go to
the benefit. So, is it a testamentary writing, a testamentary document? Yes. So, what is the effect of that? If it is a testamentary writing, it has to what? Say it out loud.
It has to form part of the whole document, the will.
No, it doesn't have to be. You can say, I'm putting the name of my beneficiary in my safe. But what does it have to comply with? Formalities, because it is a testamentary writing. Which means in this case where he says to you, here are the photos, here's the map, he has to sign that map and the witnesses will have to sign that map. And at least the testator must sign it. The same with the photos. So already we have a problem with all four wills. As I said, we can all laugh out loud. Okay, but that's why I put it in there so that you are aware of the fact. And you often get it that the testator says, I'm making the will, but I will put the name of the beneficiary who will inherit my house in my safe. Then you have to say to him, but you have to make sure, even if you just write pity on that page, you have to sign and the witnesses have to sign. Because that is a testamentary writing because it identifies the beneficiary. The same as with the photos and the map, that identifies the benefit. Or if he just said, I'm giving full ownership, that is also. That you don't often find, but you often find either the name that's being put somewhere else or photos, maps, things like that. So that is very important. You have to know what qualifies as a testamentary writing so that you comply with the formalities. Okay, any questions? So photos, maps, lists, things like that, if they have any one of those things, they have to comply.
So your expectation of us was to just add a map to draw it up, sign it.
Use your imagination. Okay. I won't expect that from you in the exam. The point today was just so that you are aware of that fact. Okay. Then let's look at your formalities. Group 1. Is your will valid?
No, it hasn't been signed on the first page.
It hasn't been signed on the first page. Big mistake. Your will is invalid.
Sorry. Oversight.
Group 2. Well, I'm going to assume that's a signature there, that little... Okay, I'll accept that. Group 3, right. Group 4. Oops. There's no signature on the first page.
We thought
It's a matter of interpretation. You're seeing it as 2, it's actually 1.
Okay, very, very important. Where must your testator sign? As a start, he must sign at the end of the will. Where is the end of the will? It's as close as possible to the last wording of the will. In the Kidwell case, there was a 13 centimeter gap, and the court said this will is invalid because of that gap. So that is on the last page, or if it's only one page, then at the end. If it is multiple pages, like most of you had, then it has to be signed on the first page as well. Where on the page?
anywhere.
Anywhere. The testator can sign anywhere on the page as long as the page is signed. Right, the witnesses. Who may be a witness to a will? What is a competent witness?
Sorry, just to go back to the multiple pages. Does he only have to sign the first page and the last page? Mustn't he just initial every page?
No, he must sign every page. Every page. I just said if it was 2 pages, like in the example here. But if it's 15 pages, he has to sign every page. Okay.
And the witnesses.
Wait, we're getting to that. Witnesses. Who may be a witness to a will? 14 years of age and competent to appear as a witness in a court. Competent to be a witness in a court.
Evidence, right?
To give evidence in court. I'm getting to the point. Do not just say competent to appear in court. What is the difference between competent to appear in court and competent to be a witness or to appear as a witness in court? What is the difference? If I say to you that Jannie Paashaas is competent to appear in court, what do I mean?
He can give evidence, he can account for what happened.
Listen to what I'm saying. He's competent to appear in court. I'm not saying he's competent to be a witness in court. What is the difference?
He can just be there. He can be in court. Yeah. He's not able to appear.
He can be
Who is competent to appear in a court of law?
the one,
Isn't it?
the one who
you
can
just
be
said it's
prosecuted.
gotta be 14 years and older.
Say it again.
A lawyer.
Only a person with an LLB degree is competent to appear in court. And that's why I said earlier, when you learn your definitions, learn it as is. Because if you say to me, a witness is a person who is competent to appear in court, I'm going to say, you're wrong, because the witness doesn't normally have an LLB degree. Okay, so he has to be competent to be a witness in a court of law. C seems like a little difference, but it makes a huge difference. Okay, so that is why I said learn your definitions as they are. Of course, when you're asking a person to act as a witness, now unfortunately the signatures are such that I cannot recognize them, but what do you have to remember? You now sitting there in the office, you've got Mr. Brink, you've got the spouse, Mr. Peterson, you've got the sister Patricia, you've got the mother Lavinia, and you've got the friend Peter. Which of those ones can you ask to be a witness to this will? Only the friend. Why? Because he's not a beneficiary. If, for example, let's say Patricia and the spouse signed as witnesses, what would the effect be? They will not be able to inherit. They are disqualified from inheriting. Does it affect the validity of the will? No, the will be valid, but they will be disqualified unless those exceptions of Section 4A apply, which states that if the beneficiary who witnessed would have inherited interstate, he will still be able to inherit, but only as much as he would have inherited interstate. So if you had given the whole estate to Patricia, but she signed, then she would not have been an interstate heir. If you had given it to the spouse, but the spouse would only interstate have inherited either a child share or 250,000, then the spouse is going to be very angry at you if the estate is worth millions. So make sure it's not a beneficiary who signs as a witness. The other exceptions are if there are two other witnesses that do not inherit, then it's fine. Or if that person gets a court order, once again costs, because it has to be a high court order, that he or she did not influence the testator. So steer away totally from getting any beneficiary to sign as a witness. And that is one of those things that I said keep in the back of your mind. Remember that a witness cannot inherit, so don't ask any beneficiary to witness. Right, so then if we look at where do they have to sign? We've seen where the testator has to sign. What about the witnesses? Where do they have to sign? They can sign anywhere on the last page. What if we have a multiple page will? What then?
Anywhere on
every page.
No,
The initial.
Full signature on the last page.
they don't have to, just the end.
They're not allowed to.
Oh, they just witness. So they just
Yeah.
Are they?
They just witness and they don't need to.
Okay.
To how? No, we'll get to how just now. Where must they sign? Does the Act say anything about the witnesses and the other pages? No, it doesn't actually. It only says they have to sign the last page. But for safety's sake, they also have to sign all the pages, and they can also sign anywhere on the page. It is a practice rule that they sign every page, so make sure they sign every page.
But if they don't, it's not invalid.
It's not supposed to be invalid, but you're going to have problems at the master's office because they're going to say it's not signed. Okay?
If they don't sign where?
On every page. Okay, then how must all of these people sign? Okay, let's just first do the when. When must they all sign? In the presence of each other. The Act says the testator must sign or acknowledge his signature in the presence of the two witnesses being present at the same time. So that means if the testator signed today and there were no witnesses, and tomorrow you take it to the neighbors and you say sign, then the testator must tell them that is my signature. In other words, he must acknowledge it. But the important thing is the two witnesses must be present together, and they must sign in each other's presence. Now, a lot of you are going to say to me, ugh, that never happens. My boss always grabs the will and he runs to this secretary and he runs to that secretary. That's fair and fine, until who comes on the scene? The disappointed beneficiary, who says, but hang on a second, let's just ask these witnesses what happened. There was a case, when was it? Not too long ago, 3-4 years ago, where the will was accepted by the master's office as a valid will, and then the beneficiaries objected to the will and went to court, and the statements from the witnesses were that the one was downstairs and the other one was upstairs. So, in other words, they didn't comply with the formalities. In the end, the court didn't accept it because the witnesses weren't too reliable. So in the end, the court said, no, we'll assume that they were there present together and they signed together. But it is very important because you will get somebody who's going to say, no, but hang on, they didn't do it at the same time. And then, of course, it's court cases. So make sure that that doesn't happen and that there will be no doubt at a later stage. Then, of course, how may they sign? In the case of the testator, he may sign by way of a signature, by way of initials, or by way of a mark. The witnesses are not allowed to sign by way of a mark. They may use a full signature or initials. And note that a full signature does not mean, in the testator's case, your normal signature. You can even write out just your nickname. That is still considered a signature. Okay, what is considered a mark would be something like a thumbprint or a cross, and that would normally happen where the testator is too weak to sign or is in hospital or has broken an arm or whatever the case may be. Just to look at your assignment quickly, to go together with these formalities that we have discussed now. Unfortunately, it was a little bit difficult for me to do it on the screen exactly as it was in the assignment, but in the assignment, the second page of your will had the bequests at the top, like we have there on the screen, and then there was quite a big gap, and then the signatures at the bottom. Okay, so what would the master say? Is this valid or not? No, because it's the same thing as in the Kidwell case, where there was such a big gap that the master said, look, I'm not going to accept this, because it is possible that somebody could write extra stuff in there or type extra stuff in there. So the possibility for fraud is too much, so that is invalid. And that is just to illustrate what it means when the court says it has to be at the end of the will. So in that case, the will would have been invalid. If the testator signs by way of a mark, then of course there are additional formalities, such as the Commissioner of Oaths, who has to be present when the signing takes place. Before the 92 Act, the Commissioner could act as a witness as well. Now he's no longer allowed to do so. So in that case, you need 3 extra parties. You need 2 witnesses and the Commissioner to sign. And then, of course, who is a Commissioner of Oaths? Certain professions, such as attorneys, are automatically, by reason of their profession, accountants, police officers. So make sure that the person qualifies as a commissioner. Of course, it is required that he then states on the certificate that he has to append that he is a commissioner. He cannot simply put attorney, that's not good enough, or police officer. It has to state Commissioner of Oaths. The certificate, there is an example in the Act of the wording that one can use. You do not have to use it. The main thing is you have to state that the will so signed is the will of that particular testator, and then, of course, that you are a Commissioner of Oaths. Where do you have to attach the certificate? Again, the Commissioner can attach the certificate anywhere on the will. The verdict is still out whether he can do it on the back on a blank page. If it was written like that, if he can write there. There's still some uncertainty. Some people say yes, it will be accepted. Some say no, it won't be accepted. Be safe and rather do it on the front. Where there's a little space like that, even he can do it there. He can make a little block and write there and put a stamp or whatever.
So the only requirement is he stating that this is the will.
Yes, because there is no signature that you can identify. It could be just a little cross, which would make it very difficult to know if it is the testator, and that is the reason for the certificate. So as I said, in the Act there is an example. He may use that example, but it's not necessary. And once again, keep in mind that disappointed beneficiary, because if these formalities are not complied with, again, there will be a problem. Now, what to do if the will is invalid? Now, to know this, and as we have two invalid wills here, we need to know what to do now. Yes?
Condemnation.
Condemnation. Okay, so first of all, you have to understand how the process works to know what to do. The first step when you have a will after a person dies is, of course, to hand it in at the master's office. Now, any and all wills that you find have to be handed in at the master's office. You cannot decide that, oopsie, my daddy changed this will. Here's the 2002 will where I was the beneficiary. Here's the 2010 one where my sister is the beneficiary. So I'm just going to hide one of them. What's going to happen if you do that? It's fraud. And what's going to happen? What are the penalties? Besides that is the civil implication. I'm talking about the criminal implication now. Okay, we have a bid for 5 years. Anybody else? Anybody else? We have a bid for 6 months. This lady's very lenient. We have a bid for 6 months and a bid for 5 years. Anybody else? Oh, we have a bid for 15 years. This gentleman is very serious. Okay, the penalty is 7 years or 140,000 rand. So it is quite a serious offence if you get caught. So rather, either or. So rather not. Okay. Make sure you hand in whatever wills you have at the master's office. Then, of course, the master will take Group 1's will and he will go, okay, not signed on the first page, rejected, invalid. What then? All cases concerning status, under which succession obviously falls, must go to the High Court. So it's a High Court application, which is very cheap, of course. Very, very cheap. Okay, so that is something you do not want to do to your clients. But if you have to, you can go to court for a Section 2.3 application. Section 2.3 says that if we are dealing with a will that is not valid because it does not comply with the formalities, the court can order, or the court must actually order the master if the requirements of Section 2.3 are complied with. And the requirements are, first of all, the will must have been either drafted or executed by the testator. The difference being, if the will is executed or there is an attempt at execution, it is easier to see Because if the testator, for example, signed the will, but he didn't have witnesses, then he did make an effort to execute it. So then it's easier to know, okay, this was probably his will. And then you don't have to look at whether he drafted it personally. But if you have just a letter, you just have group 1's first page, that's all you have. You don't have a signature or anything. Then it is important to know whether he drafted it personally, because the Court of Appeal has decided that only in that case can it be condoned. So either he must have written it out in his own handwriting, or he must have dictated it to somebody who either wrote it or typed it for him. Okay, so, or there must be some proof that he typed it on his computer. Okay, so then it can be condoned if the person has since died. Now, that sounds quite obvious, but it's not always that easy. And it has happened in one case where there was a joint will where the testators had signed all the pages except for one. Somehow, when the wife signed, she paged 2 pages together, and the one page was not signed by her, and she was the survivor. So she was still alive. And the court said, but in that case, we can condone it because it's quite clear what Section 2.3 wants to achieve. So in that case, it was condoned. So it is possible that one of the testators can still be alive. And then, of course, the testator must have intended that document to be his will. Note, and I saw it in a few people's assignments, also in my law of succession assignments, that it is not about the content of the will. The question is just, did Pity, who is the testator of this piece of paper, want this piece of paper to be his will? It's not about the content. It's just whether he intended this to be his will or whether he just wanted this to be instructions to go to his attorney to eventually become his will. Okay, do you see the difference? So it's not about the content. And of course there you can look at the content of the document, but you mainly look at surrounding circumstances to determine whether it was his intention. And of course 9 out of 10 times it will have been his intention. And then while we're talking about Section 2.3, we also have to remember that there's another section, Section 2A, which has basically the same provision as Section 2.3. But it goes about amendments and formalities around amendments. What is the difference between revocation and amendment of a will? Anybody, hands up.
Okay, so
I'm going out on a limb, but isn't revocation done by the courts and amendments by the testator? No, okay.
Revoke would be the whole will is terminated. Amendment is changes to an existing will.
Okay, as a layman, that would be correct or almost correct. But think legally, what's the difference?
Right, in terms of amendments, the formalities would be a requirement. And revocation, there shouldn't be amendments on that.
There shouldn't be amendments. Now you're getting revocation and amendment.
All right, revocation, there's no formalities.
That's correct. Okay. The difference between revocation and amendment is when you revoke a will, you mostly get rid of the whole will. But you can also just revoke a paragraph of the will. Whereas with an amendment, you change something in the will. The definition of amendment is a deletion, addition, alteration, or interlineation. So if you do any of those things, it qualifies as an amendment. And legally speaking, the difference is amendments have to have formalities, whereas revocation does not. You can just take your will and tear it up and throw it in the bin. Okay. Or if you decide, I don't want this paragraph in the will, you can just scratch it out. No formalities needed. But if you change something, you do have to have the formalities. And that is what Section 2A provides for. It says basically the same as Section 2.3, except that it just says if the amendment does not comply with the formalities, then it can be condoned. What's the difference between amendment and rectification?
I mean, rectification, I think in our assignment, the property of the woman was 333 instead of and 433, so it was
Hallelujah! One person that saw it. Most of you didn't even see it. Okay, so what's the
Then
difference?
the court obviously then said, listen, there's a spelling error.
There's the clue. The court. Amendment can only be done by the testator. The court cannot amend a will. And amendment gets done before the testator dies, because it's only him that can do it. If he's dead, he can't do it. Rectification, on the other hand, is done by the court. And the court will only do it in 3 instances. Either by adding words that are missing, by deleting words that are there that shouldn't be there, or by fixing a typing error, as in your assignment. Now, hands up, how many of you did see that? Ah, well done, because the assignments that I have marked up to now, nobody has seen it. The testator stated in that assignment that I leave my residence at 4:33, so and so and so to so and so. In the meantime, she only owned the property at 3:33. So there was a typing error, which meant rectification had to be done. Again, that small little mistake, the master is going to say to you, but there's no such a property. She didn't own such a property. Such a property does not exist. So go to court and get an order for rectification. So, again, important not to be negligent. And it's not going to help to say, but my secretary can't type. That's not going to work. Okay, so make sure you proofread. And while I'm talking about that, I got 1 or 2 assignments that really demonstrate very, very poor language skills. People, if you do not have the language skills to make a proper sentence and to answer it properly, don't draft a will. You are going to land yourself in serious trouble. Also for the exam, you have to answer properly. You can't just give me random clues. I mean, I don't speak SMS language, so I can't put it together. So it's not going to earn you marks. So answer in proper sentences, please, because what I cannot understand, I cannot mark. Okay, right, but that as far as amendment and rectification is concerned, so the one the testator does, and he has to comply with the formalities. The other one, the court does. And again, your definitions there are important. Okay, so that brings us now, we've now seen that 2 of our wills are already landing up in court, but let's look at the content of the wills now. Oh dear, and now they all want to dive under the tables.
I'll ask you something again, to go back to validity. You're only looking at the piece of paper, not the content.
Yes, yes.
Okay.
That's a very good point that the gentleman is making. When you're looking at the formalities, you're only looking at what it looks like on the paper. So if we take, let's see, which one? If we take one, let's say this was the only page, and if the master gets this and it's the only page and there's a signature and the witnesses, it all looks in order. So the master is going to accept this piece of paper. He's not going to know if the witnesses were there at the same time. He's just going to say, oh, this looks in order. Only then will the beneficiaries come and have to go to court and say, but it doesn't comply because the witnesses weren't there at the same time. Okay, so the master strictly looks at what it looks like on paper, on the face of the document. Okay. Any other questions about that?
When they give it in at the master, and the master's obviously just looking at the formalities and if everything is there. But I mean, there's no way for them to know that that is not actually the final will. There were 3 others. If nobody actually contests eventually.
If nobody contests it, then that's the way it is. It's up to the beneficiaries to contest the will and to object to that will. Okay. The same if the master receives it and it has been falsified. If somebody did fraudulently copy the testator's signature or try to make the testator's signature, the master's not going to know. He's just going to say, okay, that's fine, we accept it. And then when it comes to the liquidation of the estate, the beneficiaries will have to say, hang on, this is not the will or it's not the testator's signature, and they have to contest it in court there. Okay, that's the way the process works. Okay, so if we look at the content of the will, of course in South Africa we have a very wide freedom of testation. A testator can basically do whatever he likes to do. He can make any provision he wants to in his will, but he has to keep in mind that that will has to be interpreted according to his intention, and that there are certain limitations imposed by common law and by statute or legislation. Limitations such as the Immovable Property Removal of Restrictions Act, which states that if you want to have a fideicumissum over immovable property, you cannot have it for more than 3 generations. In other words, you can say my farm has to go to my son, after him to my grandson, and after him to my great-grandson. But it stops there. You cannot say for 100 or 99 generations. This provision was brought in because of the fact that people used to say for 99 generations. Now, if you don't advise your client not to rule from the grave, it is going to be very hard for your generations to come. Note that it's only over immovable property, it's not over movable property. So you can say my antique watch or my antique table has to go for 99 generations, but of course you make life very difficult for your beneficiaries if you do that. The other indirect limitation that we find is with maintenance. Of course, children are entitled to maintenance, as is the surviving spouse, in terms of the Maintenance of Surviving Spouses Act. There is a whole section in your textbook about the maintenance of surviving spouses. A surviving spouse has a maintenance claim. Note that it is a claim. It has nothing to do with matrimonial property. It is something that she can claim as if she's a creditor against the estate. So what will happen is the testator dies. If they were married in community of property, the estates will be split. She will have her half and his half will be in his estate. But she could possibly still have a claim for maintenance against his estate. And that is a claim that she has to submit. It's a claim for reasonable maintenance, and there are a whole list of factors that are to be taken into account. Please note that if I ask that in the exam, you have to give the factors. It's not good enough to say standard of living, etc. What does etc. mean? If you put that in your answer, you will not get the marks, and it just shows me you don't know what it means. Right, then of course, a testator cannot make provisions that are against public policy. Public policy has been developed over hundreds of years, it changes constantly, but there are certain things that are considered against public policy. Things such as interfering with a marital relationship. You cannot say, I leave the farm to my 3 daughters, X, Y, and Z, But unless Y divorces her husband, she's not allowed to have it, because that is interfering with the marital relationship, and you cannot control that relationship by the purse strings. Okay. If, however, you say, I leave the farm to my daughter X and she has to go and live there, and it appears that it will be very difficult for her to live there because her husband has businesses in Cape Town, then you didn't intend to interfere, but it's a practical consequence. And then the only thing that will happen would be you will be making life difficult for your daughter. Okay, so remember, public policy says you may not interfere with the marital relationship. You may, however, as we had in our example, say that we stated the spouse should inherit until he remarries. That is not interfering with a marital relationship. It is also not preventing a person from getting married because he has been married before. It is simply a practical thing because you want to take care of him until he remarries. So that is quite acceptable. You may require a person to live in a certain place according to public policy previously. Under the Constitution now, there is a question mark about this. If you're restricting a person's freedom of movement, are you still allowed to do it? But that has not been tested in court yet. So at this stage, the old rules stating that you may do it still stand. Then, of course, faith clauses. Through the ages, that kept changing. First, you were not allowed to do it, then you were allowed to do it, then you were not allowed to do it, and it keeps changing as public policy changes. And again, that is now entrenched in the Constitution. So again, the question would be, are you allowed to say you will only inherit this farm if you marry a person of this faith? Probably not, because it's against the Constitution. But that also has not been tested yet. You all know what the Constitution says with regard to discrimination. You all know those factors. I don't even have to tell you. So that is something that you keep in the back of your mind when you draft a will. When your testator says, my daughter is allowed to get this farm as long as she marries inside the Jewish faith, you have to say to him, but sir, I'm very sorry, I know that's your faith, but our Constitution says you may not do that. So let's not make life difficult for everybody. Let's not put that in the will.
So what happens in the case that the client does put that in the will? Maybe she drafted her own, I drafted my own will, and I do put that in the will. Does the beneficiary then get the estate?
Okay, I'm going to explain that to you now. If you do that, if you put a clause in your will that is against public policy or against the Constitution that we have now, let's say you say, my daughter may only inherit the farm as long as she marries inside the Jewish faith. And she now wants to marry a Christian. Then she can go to court again. Again, you are talking about a court order to have that condition scrapped. And what happens is the court only scraps the condition itself. So she then inherits the farm without that condition being attached to it. Okay, so any condition that's against public policy or against the Constitution will be scrapped and the beneficiary will inherit without that condition.
But then can I write a will perhaps and say, my son, I leave my property to my son, but if he gets married, the spouse does not inherit from what I've left?
Yes, that is fine. That's not because you're not discriminating, and you also it's not against public policy to say only my son gets it. Okay, you're just saying that person is not allowed to get it. So there's nothing that indicates that it's against public policy. So that is fine. Okay, so all of those you need to keep in the back of your mind. Then, when we get to the content, there are various legal concepts that you can use in a will, and that's why I gave you the facts like I did, to see what you are going to do with the various legal concepts. Now, again, the definitions of all of these are important. If I wake you up in the middle of the night and I ask you, what is a time clause? You have to be able to, before you even awake, you have to be able to say it's a certain event that will happen in the future. If I say to you, what's a condition? You have to say it's an uncertain event that may or may not happen in the future. If I ask you, what is direct substitution? What is a fideicumissum? What is a usufruct? What is a trust? You have to immediately give me the definition. Because if you do not know the definition, you will not be able to identify it if I give you the provision. And I say to you, okay, Mr. Brink in our case has written this in his will. What is this and what is the effect of it going to be? If you cannot identify the concept, you will not know what the legal effect, first of all, will be, and secondly, what the practical effect is going to be. So it's very important to be able to identify the concept so that you can apply the rules that go with the concept. Okay, and together with that, you need to look at dies cadit and dies venit. Dies cadit, please note there's no R in it. Latin has never ever known a soft sound. They do not have a S sound. So it's not dies cadit, it's dies cadit. Cadit like in K. Okay. And dies venit. Dies cadit means the time when your rights vest. Dies venit means literally the day has come, the day when you can use your rights, when they become enforceable. Now, I'm going to give you a very simple example to show you how it works. If the testator says in his will, I leave my car to John, he may only drive it when he gets his license. When does dies cadit take place?
On death.
When you get your license.
On death.
So,
Okay, we have a bid for on death and we have a bid for when he gets his license. The testator's death. Please note, not immediately. Immediately when? Immediately when the testator dies. Okay, you cannot say dies cadit takes place immediately. It doesn't answer my question. Okay, always when you answer a question, I must not be able to say to you, but what does that mean? Okay, so dies cadit on the death of the testator. And dies venit, when will John be able to enforce his rights? When he gets his license. So in this case, the two moments are split. Dies cadit and dies venit, they are moments apart. Usually they take place together. Usually it's either that he gets it immediately when the testator dies and he can enforce it immediately, or it's postponed, both postponed until a later stage. Remember, dies venit cannot take place without dies cadit. You cannot enforce rights if you don't have them. You have to have them first. So dies cadit always first. Okay, and venit means the day has come. So always after dies cadit. Right, so let's have a look at the content of our will.
I'll ask you a quick question. The definitions that you refer to in the terminology, that counts as definition, the adequate definition, please?
Yes. While you're asking that question, just lend me your book quickly because I've put mine away. Okay. In chapter 1, there's a table, and we've done it in the way that you can close the one side and write the definition down, and you can close the other side and write the term down. Okay, and it was done specifically so that you can learn the definitions like that.
7, 8, 9, 10, 11, 12, 13, 14, 15.
Yeah.
So 7 to 15.
But while you're talking about that, please take note of tutorial letter 501, which you will find on My UNISA, which tells you what you have to study. You don't have to know all of them. Okay.
There's a whole 8 that you have to know. No, 10, 11, 12.
So it's an easy few marks that you can study. Okay, let's have a look at the contents of your wills. And there's one specific one that I am looking for, and that is where the fact stated that the testator wanted to leave his farm to his sister Patricia. Okay, group 1 says, to my sister Patricia Bombshell, I bequeath my game farm in the northwest and a map of which I attach, which they never did. She is required to settle on the farm within 3 years of my death, failing which the farm will form part of the residue of my estate. That was theirs. Group 2, I bequeath my game farm in Northwest to my sister Patricia on condition that she settles there within 3 years of his death. Okay, okay, we'll assume of my death, as per attached farm map. No map. The master lost it. Okay, there's a good explanation. Okay, group 3, my game farm in Northwest to my sister Patricia Bombshell on condition that she settles there within 3 years of my death. Also falling into the trap. Group 4, to my sister, no, hang on, to my sister, I leave the game farm on condition that she settles on the farm within 3 years of my death. Right, so 3 of the 4 fell into the trap, and number 4 sort of tried skirting it but wasn't quite successful, group 1. So let's have a look at what you did. 3 out of the 4 said, I leave my farm to Patricia on condition that she settles on the farm within 3 years of my death. Most of you didn't even say what happens if she doesn't, which of course means then nothing can happen. But had you said, if she does not settle, the farm has to go to my brother Ben. So you have to say something. What happens if she doesn't? One of you said it goes into the residue. Okay, you tried something. That's fine. Right, what have we got here? What kind of a legal concept is this? What is the definition of a time clause?
A certain event that will happen in the
A certain event that will happen in the future. Is it certain she's going to go and live on the farm? So is it a time clause? Come, simple yes or no?
Is it no?
Suspensive condition.
Okay, the answer, in other words, to the time clause issue is no. Okay, because it's not certain she's going to live there, so it cannot be a time clause. It's a condition. It even says on condition that is attached to a time limit, but that doesn't make it a time clause. It's uncertain, so it's a condition. The gentleman there said it's a suspensive condition. Is he correct? What is the definition of a suspensive condition? So we start patching in the book.
Isn't it dependent on something that has to happen?
What is what dependent?
Well, she's not going to get the farm if she doesn't go stay there.
Yeah, put it in legal terms. No, it can't be absolute because it's a condition. No, what is she going to get? Ah, thank you. Legal thinking. She's going to get vested rights on the farm only if and when she goes and lives on the farm, according to this provision. In other words, correctly said, a suspensive condition. She's going to be kept in suspense until she goes and lives on the farm. So her rights will only vest once she goes to live there, which means DSK, the vesting of her rights, will only take place once she goes to live there. What will the effect of that be? When you get ownership, in other words, when the right of ownership vests on you, what do you get? What is the content of ownership? You can sell it or pass it on to your beneficiaries. Rights of disposal, you can get rid of it. Yeah. What else? Enjoy it. You can get the income from it. In other words, you can farm it. And before your rights vest, you've got nothing. And what does that mean in practical terms?
That it can be settled. It can revert to intestate.
DS Velit has not taken place.
DSK hasn't even taken place. Nothing has taken place. What does it mean in practical terms? It means no income. It means you cannot sell it. It means you've got no enjoyment of the farm. It means you cannot even appoint a manager to farm the farm for you. Was that your testator's intention? No. So what have you done? You messed up. Yes, you messed up. Because the way you have put the provision means that your beneficiary has no rights until she moves there. Let's say it takes her 2.5 years to sort her affairs out before she can go there. What's going to happen to the farm? Lose its value, the cows are going to die, the pigs are going to die, the state's going to be on your case, the SPCA is going to be there, and that was not the testator's intention. What is the testator's intention?
She moves it. She owns it.
Oh, this is to inherit.
Yeah.
No. What if it was your farm, what would you want?
I'd want the best person there to maintain it.
To maintain it, for the farming to carry on, for the farm to be maintained, for it to be economically viable and carry on being economically viable. So that is your testator's intention. So how are you going to get to that? That's his intention. He wants the farm to be viable and to continue, and he wants to ensure that she goes and lives there. How are you going to get that?
In other words, how would we structure the will to enforce that, to make sure that happens? By being an absolute legacy, saying...
No, he wants to put that condition there. He doesn't want to say, I just leave it to her, because he's worried that she's never going to go live
So
there.
then his intention is if she doesn't go there, that somebody who will gets it.
Yes, but we've seen that. We've said if she doesn't, then Ben gets it. But how do we ensure? That's the provision that you had. I leave it to Patricia on condition that she settles there. If she doesn't, it goes to Ben. We've seen it's a suspensive condition. She doesn't get any rights. How are we going to ensure she gets rights when the testator dies? Ladies and gentlemen, it's a question of punctuation. I leave my farm to Patricia. If she does not go and live there, within 3 years, it goes to Ben. What have we done now? I leave it to Patricia. DSK'd it when? On my death. She gets it on my death. In other words, she gets all the competencies, all the rights of an owner on my death.
She loses those rights after 3 years of his death.
Thank you. So what have we done? What type of condition is this? What's the opposite of a suspensive? Resolutive or terminative? Yes. It's a question of simple punctuation. And that is why your drafting skill is so important. Because by simply changing your sentence, you have changed the entire effect and you have achieved what your testator wants. He wants her to be able to carry on with the farm, but if she doesn't goes and lives there within the 3-year period, then he wants somebody else to take over because he thinks 3 years will be enough for her to sort her affairs out in the city, to be able to move, and for her to then take over the farm. She doesn't need 10 years to do it, she only needs 3 years. And if she doesn't do it in the 3 years, then somebody else has to take it over. Which also means we can finalize the estate immediately because we can register this condition against the farm's title deed and Bob's your uncle. Do you see why it is so important to not only say, oh, and that's what 3 out of the 4 of you did, is my testator says, I want the farm to go to her on condition that she lives there. Didn't think, what does it mean? What does it mean in practical and in legal terms? Wording, very, very important. By simply putting the full stop in a different place, the whole meaning changed. Are you all with me? Are you totally shocked? Any questions?
He hasn't given any timeline to her staying on the property. So she has to move there within 3 years. But he's not saying that she has to remain there.
No, that's what I'm saying.
Yeah. So once it's got it.
Once it's hers, it's hers to do whatever she wants.
Yes, because that's his idea. It has to be hers. If he wants it differently, if he says, but she has to stay there permanently, then, of course, you have to add that. You have to say she has to go there within 3 years and she has to stay
But
there.
is that not a restriction, constitutional restriction on the rights of...
Yeah.
Possibly, yes. And then you still have to say, if she doesn't, if she leaves the farm, then it has to go to someone else. Somebody said it has to go into the residue. It's possible, but it makes it difficult. It's better to have the direct substitution there to say, or at least the fideicommissory substitution, or, well, depending on how and what you put there. In this case, it'll come down to a fideicomissum because she gets it, and then at a later stage, if she doesn't go and live there, it goes to Ben. It is better to put somebody there to take her place.
So what happens if Ben doesn't want the farm?
If Ben then says he doesn't want the farm, then it is Patricia's farm because she has all the rights, and then she can do what she wants. If he then says...
That would be an... well, it's not acceleration.
No, it's not acceleration. It's simply the fideicommissory then says, I don't want it, which means the fideicomissum would then not take place. It would stop with the fiduciary, and it's in her estate then.
In terms of this question, there was only 3 beneficiaries of the residue of the estate, the mother and the 2 children. So in this case, if we left it to the residue, or if he left it to the residue of the estate, they would be the beneficiaries of that farm if she doesn't move there.
Yeah. After the 3-year period, then they would, but that will mean your finalization of the estate is extended, because you first have to see if the 3 years, what's going to happen in the 3 years.
Okay. So this way there's absolute...
Yeah, in this way it's... Yeah. Okay, so that just to show you how important it is to think what the consequences would be. As we've seen now, it comes down then to the fact that all the rights vest on her at the testator's death, and that means she's got all the rights and benefits of being the owner, and it simply comes down to drafting skill.